Good morning, ma'am. You're Crystal Robertson,
Doesn't have to say that.
and this is 25 DCCR 1526. And Ms. Robertson is charged with forging a governmental instrument. And what is the announcement?
I was just repaying on this a little while ago. I'm still
Yeah.
working. It's for a reset on that.
Any issues? All right, we'll just do a normal reset. That'll give Mr. Burbank some time to get all the discovery from the state and then offer, and we'll see where we get at that next court date. Make sure you stay in touch with him, and he'll let you know when you need to be back. You're free to go. And then Kingston Walker, 2 cases, Mr. Burbank.
That's your right.
Um, yeah, I saw that back there.
And people.
Good morning. Are you Kingston Walker?
Yes.
And this is clause numbers 25 DCCR 0861 and 0862. Mr. Walker's charged with tampering or fabricating physical evidence with intent to impair and possession of a prohibited weapon. And what is the announcement?
Your Honor, I misread state's offer because it's asking for something that I did not explain to him. I've been
Okay.
out of pocket for about 2 weeks.
And I recognize how busy Mr. Burbank's being judged. I'm not opposed to reset.
Okay, we'll do one more normal reset.
Thank you.
Mr. Walker, make sure you get in touch with Mr. Burbank before that next court date so you can go over everything with him, and then we'll get an announcement.
Yeah.
All right, you're free to go.
I had somebody else do it.
You did. Raheem Allen.
Wow. So I'll be out there.
So are you Raheem Allen? So Mr. Allen was here not that long ago, and we figured out when we were in court that day that there had been 15, I think it was, positive drug results, patch results that we had not received. We received them that day. I raised his bond on that day, went into custody, has made that bond, has a drug patch on, and the first drug patch received tested positive.
That was the one I had. That was the one that I had. I was
So you still had the one in court when they didn't take, you didn't take it off in jail. How long were you in jail?
I was like overnight. I got out when I got out the next morning. They told me to go exchange it.
Did you?
Yes, ma'am.
So when are you supposed to switch this one?
I just did a switch Monday.
Oh, you already did the switch Monday. So we should have a result within what, a few days, Anna? Do you know how long that takes? Okay, well, that at least somewhat explains that if that's correct. So I want to make sure you understand, obviously, I'm going to get that result within a few days. If it's positive, your bond's going to be high enough to where you're not going to just make it out overnight. Do you understand? If you test positive again for anything, you will be back in custody. We'll have a hearing. And at that point, based on the length of time, there are sometimes I can make findings that bonds are not even appropriate. So you better not test positive. You better not be around anybody that's doing it. You better not come in and say, I didn't do it. I touched something or somebody touched me. No excuses. This next one better be negative. Okay. All right. Y'all are free to go.
Thank you, Your Honor.
I'm sorry, Judge.
Yes.
I didn't want to interrupt you. In light of his criminal history, would the court consider, now that he's back out on bond, the GPS monitor in this case?
What's the underlying offense of aiding? I mean, he showed up every time. And there's not necessarily a complaining
I
witness.
just wanted to ask. It's
Okay. Yeah, I would say if there's any other
If something
issues
comes
that
up, I'll file.
comes up, let me know and file something. Otherwise, my main thing, he's been here every time. We just didn't realize he was testing positive for that long.
And I did.
All right, you're free to go.
Thank you. Judge.
Yeah.
Have the approach on different issues than other
But which one?
On Mr. Crane.
I'm sorry?
On Mr. Crane.
Yeah. Who's on the,
It was the case you sent to ISF as part of the deal. So
are we off on the?
we don't need to be on the record. This is just a question.
Okay, we'll go off
for
the
you.
record.
So,
Who's Eric Porter? I don't know why.
I don't know why it said that. Judge, she's next door.
Okay, sorry.
She's the
Carry
best
on.
friend. I am not her.
no, let the record reflect it. So we went back and he told me, I'm having a baby. And what about having a baby? Well, his mom stopped me outside. His fiance is scheduled to have a baby today, 2:00, like an induction today in Galveston.
Yes.
So I asked Ms. Malfino if could he turn himself in on Friday evening or something like that, so he can take her to have the baby and get her home safely. And then I said his mom is out there, not the mom of the baby.
Right.
Sorry to clarify, but they're scheduled for her to be induced today at 2:00 in Galveston. And inducted. Yeah, we couldn't decide if the correct word was inducted or induced. Inducted.
She's gonna be inducted into the Motherhood Hall of Fame. Like that. I feel like that. I thought we all have, right? What are your thoughts?
If he hadn't done well while on bond, I would be more hesitant. I would appreciate if maybe it wouldn't be any later than Friday.
Yeah.
Oh,
Now
no.
another
Yeah,
weekend.
I would say.
No, not a
And,
weekend.
and Friday.
Let's get Jaron Crane back out, please. Oh. Sorry.
Especially Judge, since he knows what you've ordered, and then he'll be back out in Galveston and on the road.
Yeah. All right, so that technically means he'll still be, I'm gonna put him on all right, that'll be a condition of his probation. Just thinking about the right way to order it so that. All right, Mr. Crane. So you are going to have a baby today, is that right?
Yes, ma'am.
Well, here's what I'm going to do. Your attorney's talked with me. The assistant district attorney is not arguing against me doing this, what he's requested, but I want to make sure you understand what all of this means. I'm going to let you turn yourself in this Friday at 12:00 noon. All right. So that gives you a couple of days to get everything taken care of, see the baby born. And then you have to turn yourself into the Jefferson County Jail by noon on Friday. That's part of your probation now. And so what that means is if you don't turn yourself in on time, it's a violation of your probation. And so you're going to be right where you don't want to be, right? So I know you don't want to go for those 3 months, but it is intended to help you make better decisions. 3 months is better now to miss out of your child's life than potentially 5 to 99 if you violate your probation. So go listen, get the tools you need, turn yourself in, make some positive changes so that you don't ever have to look at me in this position again and we're not here having some really bad conversations. Okay.
Yes, ma'am.
So I'm going to let you go today. I'm going to let you turn yourself in on Friday. And then hopefully everything goes just like we already talked about and you change your life and we're in a good place. Okay. All right.
Thank
You can
Judge.
go back and they'll let you go from back there. Thank you.
May I have the probation department test Miss August before I sign her paperwork?
Sure. Who's is that?
It's all.
Miss August? Come up, Miss August. Miss August, you're wearing sweatpants.
Well, she was prepared to go in custody.
Oh,
That's
you-
the agreement. She's-
Oh, it is.
Yeah.
That makes sense. Have a seat in the jury box. We're going to get you tested also first this morning before you go in. Okay?
Yes, ma'am.
And spit your gum out on your way over there at that trash can.
Which is why. Thank you for that.
Mr. Rojas, you have William Bonilla. Good morning, sir. You William Bonilla? And Mr. Bonilla is charged in cause number 25 DCC 0719 with evading arrest or detention with the use of a vehicle. And what is the announcement?
Jesse, this also is a motion to revoke based on,
Oh,
based on that. Yeah, he's got evading.
Oh, I'm sorry. There's two cases. So
Yeah.
we've got a new case of evading in that case. And then we've got 25 DCCR 0174, a driving while intoxicated that he's on probation for.
That's correct, Your Honor. And I spoke with Mr. Coleman about this last week, and I got the video finally on Friday. If I can get one more reset, I'll have a chance to look at that and get Mr. Boney in to look at it and be able to make an announcement next time.
It's based on a published judge.
All right, Mr. Bonilla, I'm going to reset your case, a normal reset. Make sure you go in, visit with Mr. Rojas so y'all can go over everything, review everything he has, and we'll get an announcement at the next court date. Okay, you're free to go. Just wondering why I was messing up. I didn't
Right.
do my lines. That's okay. I used to. Brandell Griffin, Mr. Rojas. And Mr. Pullman, yeah. Good morning. You are Brandell Griffin. And Mr. Griffin, in cause number 24 DCCR 1666, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from June 24th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine and follow all of the rules and conditions of probation. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you want to reject that offer? All right, we'll get that case set on the trial docket. And Mr. Griffin, Mr. Rojas has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else. Is that okay with you? So, Mr. Rojas, you are released. Mr. Griffin, we will appoint someone today. If you'll have a seat on this side of the courtroom, watch for the clerk. She'll call you up in just a minute and let you know who your new attorney is. Yes, sir. Mr. Rojas, Darius Sparks. Good morning, you're Darius Sparks.
Yes, ma'am.
And Mr. Sparks is charged in cause number 25 DCCR 0754 with a third-degree felony offense of assault, family violence by impeding breath or circulation. And what is the announcement?
Judge, I believe we're asking for a recess so that Ms. Malpino can send a letter to the complaining witness and get her input on a possible offer of the
Sure.
deposition.
That's true, Judge. I have not heard from her since the original correspondence back in June of 25. If the
Okay.
court would allow me just a short
Sure.
period to send another one. We do have an alternative resolution.
All right, we'll just do a normal reset. Mr. Sparks may make sure you stay in touch with Mr. Rojas and your bondsman. They'll let you know when you need to be back. All right, you're free to go. And then you have a sentencing with Thomas Valentino, Mr. Rojas. Good morning. Are you Thomas Valentino? And Mr. Valentino was previously in court and entered a plea of guilty. Hold on, I'm sorry. In count one only of the indictment to the state jail felony offense of theft of material. We reset the case for sentencing to give Mr. Valentino some time to get his affairs in order. And Mr. Valentino, just a couple questions. Have you been arrested for anything since we were here last
No,
time?
Your Honor.
All right. Is there any reason not to go forward with sentencing, Mr. Rojas?
No, Your Honor.
Ms. Malfino?
No, Your Honor.
All right, then at this time, sir, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You will receive credit.
Wasn't the agreement 16 months? Judge?
Not to 18.
Hold on, she'll pull up the paperwork.
I thought it was 16.
On the plea agreement that y'all signed, everybody signed.
Okay. Can I have them all?
Sure. Yeah, because that's the plea.
That is the plea papers, but okay.
Okay, I'll hold it for just a minute. Y'all just stay here in the courtroom, please. See, is Mr. Oppenstein the only?
Yes, he's here.
Are you ready on, well, Coker's set for a plea. Are you doing paperwork on that one?
Yes, he's going, may I approach?
Yes. Terrell Coker is French.
Mr. Coker. Gave that to me. The offer. I tendered it to him and we're gonna accept it. I just wanted to make sure he understood.
It's set today for a plea, so we need to get that taken care of
we-
today. Okay, I'll hold it.
Yeah.
And then are you ready on your sentencing? Or are you still going over your pre-sentence report with Ms. McBride?
I'm ready.
All right, Kelly McBride. Good morning, ma'am. Are you Kelly McBride? And Ms. McBride was previously in court in cause number 25 DCCR 0044, entered a plea of guilty to the third degree felony offense of obstruction or retaliation. I've received that pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
Your Honor, there's no corrections that we want to address because of the circumstances around it. We are agreeing and we'd like to move forward.
Any issues?
No, Judge, just to let the court know, she also will enter a plea of guilty to the that was part
Right.
of our plea bargain. So
Okay.
after the court sentences her here, not follow this, she'll go down the hall and enter back with all of those conditions to be imposed as well.
Thank you. And is that your understanding as well? Y'all will go down and take care of that today?
Yes, Your
All
Honor.
right, then, Ms. McBride, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would have a felony conviction, and you could go to prison anywhere in that punishment range between 2 years and up to 10 years. Do you understand? Excuse me, I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, before y'all go down there, probation will go over your paperwork, and then y'all can go down there, and if you think it'll be a little bit, they can go take care of that and come back. Okay, she's gonna take care of you before y'all go down there.
Now I'm going to take care of Mr. Coker.
Perfect. Thank you, sir.
Thank you.
I'll hold it for that. Mr. Comerford, are y'all ready on Mr. Mr. Chavarria? Sorry. Yes, they are. All right. Again, sir, you're Carell Gilbert.
Yes, ma'am.
And Mr. Gilbert tested negative for everything. And so Mr. Gilbert was previously in court in cause number 25 DCCR 1009, entered a plea of guilty to the third degree felony offense of driving while intoxicated, third or more, I've received that pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Yes, sir.
Any additions or corrections?
No additions or corrections, Your Honor. However, we did have one recommendation adding revoke.
Sure.
Nothing from the state.
So with regard to, obviously the recommendation here is for, safety. What is your request on that, Mr. Chavarria?
You may make argument with that or
Yeah,
just-
go ahead.
Okay. Our specific request is that that be held in abeyance and that Mr. Gilbert be asked to submit to some recurring UAs so that the court is satisfied with his compliance and his progress on this offense. I will note a few things, Your Honor. Mr. Gilbert took responsibility for this as part of the pre-sentence investigation. He took responsibility for it at the scene, actually, as well. He has been working at a good job with good pay for about 3.5 years, Your Honor, as a welder. And he's married. He has mortgage and car and all the normal things that people are expected to have. I think he's in a good position in his life, and submitting him to this safety would be a major disruption to that. As for the actual plea agreement that was agreed upon, safety was not requested by the state. That was not part of the specific terms at that time. He was also seen by a individual named Miss Melissa Posey, who's a licensed chemical dependency counselor, and that's on page 3.
Mm-hmm.
And her recommendation was that he enroll in and successfully complete an intensive outpatient program, such as a JCDI. And we would be in agreement with that as well, Your Honor, if that's appropriate, in lieu of the safety.
What's your position, Mr. Smith? Are you?
Judge, it wasn't part of the plea agreement. I didn't think that it was necessary at the time that the plea offer was made. The only thing that concerns me is the fact that he tested positive for alcohol when he did the concern, but we would leave it up to the court.
In the end, this wasn't just another day in felony court. We saw a pregnant defendant facing serious probation concerns, a man who lost probation after refusing to accept responsibility, and another defendant given one last chance before going back into custody. Some people walked out of the courtroom with hope, others walked out in handcuffs. And that's the reality of the justice system. Every decision, every test, every missed opportunity can change a life. The judge made one thing clear today: a second chance only works if someone is willing to use it. The real question is, if you were standing in that courtroom, would you have made a different choice?